Greetings, my name is Ben Miller and I am an attorney with MNK Law. We are not your typical attorneys. At MNK Law, we diagnose issues by asking in-depth questions and intentionally listening so that we can achieve a better resolution of the challenges our clients face. Our unique perspective as business advisors enables us to provide our clients with realistic outcomes when faced with complex legal issues that arise as a consequence of conducting business in the state of California. Today's presentation will provide a roadmap overview of what employers can expect when faced with a charge of discrimination from the United States Equal Employment Opportunity Commission, also known as the EEOC. In general, the EEOC is responsible for investigating administrative complaints of employment discrimination under federal anti-discrimination laws. The investigation usually begins when an employee, or the charging party, presents a charge of discrimination against an employer to the EEOC. This is a simple form that contains the particular allegations of discrimination. By doing this, the employee has started the process to exhaust his or her administrative remedies, which is a prerequisite to being granted the right to file a federal discrimination lawsuit. If the EEOC concludes that the information obtained during the investigation does not establish a violation, it dismisses the charge with no further investigation. This means that the EEOC will not prosecute the charge. In this circumstance, the EEOC still issues a notice of right to sue to the employee before it closes the matter. The aggrieved employee then has the option to file a lawsuit having exhausted the administrative remedies available with the EEOC. At the outset of the administrative process, the EEOC may refer the parties to mediation, where they will attempt to resolve the issues that gave rise to the claim of discrimination. Charges that do not settle pursuant to an early mediation are subject to further investigation and action by the EEOC. If the EEOC decides that a charge warrants further investigation, it will solicit the parties for additional information and supporting evidence. The investigation still may not uncover sufficient evidence for the EEOC to find a violation of law. In this case, the charging party has issued a notice of right to sue, and the EEOC has no further involvement in the charge. If the EEOC ultimately finds reasonable cause to believe discrimination occurred, the EEOC must generally attempt to engage the parties in a process called conciliation, which is similar to mediation, except the EEOC acts as the intermediary. At the conclusion of negotiations, the EEOC will present its conciliation proposal to the employer. The employer will usually respond within 10 to 14 business days, either agreeing or submitting a counterproposal with modifications. The EEOC has the final decision-making power to approve the terms of a conciliation proposal and resolve the charge. A successful conciliation will resolve the charge. The parties then execute an appropriate agreement memorializing the terms, and the charge is closed. Terms can include compensatory damages paid to the charging party and mandates to the employer to implement new policies to prevent subsequent violations. In this regard, the EEOC will supervise the settlement terms between the employer and the charging party to ensure that adequate relief has been provided. Although neither the employer nor the employee are required to participate in conciliation, many employers choose to utilize the process and pursue an early resolution to avoid higher damages, including punitive and liquidated damages that the EEOC or the employee would seek to recover in a litigated matter. A charge that is not successfully resolved through conciliation may proceed in several different manners. First, the charging party can request that the EEOC issue a notice of right to sue. If this occurs, the EEOC closes its case and the charging party is permitted to initiate litigation. Second, the parties may reach a settlement on their own, in which case the EEOC supervises and approves the same. Third, the EEOC can elect to file a lawsuit against the employer based on the charge. The EEOC only does this a small percentage of the time, and typically makes this election in cases where the investigation uncovered systematic or widespread discrimination beyond the initial allegations. Although this process may seem formulaic and predictable, the strategies employed in navigating the various stages should be tailored to suit the seriousness of the particular allegations at issue and the supporting evidence uncovered in the EEOC's investigation. An effective attorney will find the appropriate balance between cooperating with the EEOC to minimize the conflict and vigorously defending the client's employment practices to avoid liability. If you have any further questions or require assistance in responding to an EEOC charge of discrimination, visit our website at mnklawyers.com or email us at info@mnklawyers.com. Thank you.